Hello and welcome. I'm John Featherston, the CEO of RISMedia. Today's RISMedia premiere is hosting our discussion, which is Brokerage in the Balance, addressing anti-lawsuits head-on, antitrust lawsuits head-on. Today, I'll be joined by four esteemed colleagues, each servicing our industry in different capacities. Darryl Davis of Darryl Davis Seminars will co-moderate today's session. And Darryl has a lot of great ideas about what we should be doing. James Dwiggins, the CEO of NextHome, and Anthony Lamacchia, the CEO and broker owner of Lamacchia Realty, represent the brokerage sides of our business. And they too have great ideas on how we should be acting in the months and years to come. And of course, we're going to be leading off with an incredible legal mind. Jessica Edgerton is the extremely respected attorney who serves as chief legal officer of leading real estate companies of the world. Before I bring Jessica onto the stage, providing you with a current legal landscape of all of these lawsuits that we're facing, or at least a taste of some, I want you to be aware that although three major organizations, Anywhere, RE/MAX, and Keller Williams, have opted to settle in the Burnett case, none of these organizations have admitted any wrongdoing. What we're focusing on today, however, is to try to help and provide you and other real estate brokers, agent team leaders, and individual sales agents with clarity and direction as to what you could be doing in today's marketplace and heading into the future, and to make sure that you and your agents are better informed as to what other leaders throughout the nation are doing to address the issues facing us and to objectively help you stay ahead of the potential changes that may be coming down the pike and how to best implement solutions to address these challenges. Your clients want to know what's going on and how it affects or doesn't affect your ability to do business with them and for them. With every crisis lies an opportunity, and RISMedia's premier service is committed to keeping you, our subscribers, informed and equipped to meet the challenges and become the total resource in real estate that you have to be. The better to serve your buyers, sellers, and investors, you have to become a better resource. Now, you'll notice up on the screen, you're going to get a use discount code to join Premier if you haven't already. If you join Premier, you'll be getting access to all of our reports, including the report on the current landscape of the lawsuits throughout the country and solutions that are coming down the pike. We believe that information is your currency, and that RISMedia Premier webinars just like this one are helping you stay informed and on top of the topics that are affecting your business. Now, leading us off on our discussion is Jessica. So Jessica, let's get rolling. Let's tell our audience what's going on and, in your opinion, what we should be doing.
Fantastic. Thank you so much, John. Thank you, Darryl. Thanks to my fellow attendees here and panelists. So here's what we're going to do. I am going to give a very brief sort of lay of the land update in terms of what the procedural landscape looks like. Before I do that, though, I just want to do a few quick disclaimers. First of all, none of what I say, I have a law degree. I have one client that's leading RE. None of this is legal advice. This is information and idea sharing only. You got to follow your own attorney's advice, your own attorney's recommendations, etc. I don't have a crystal ball. None of us do. Anything and everything could change literally while we are doing this webinar. And finally, all of this is just my opinions. One lady with a law degree here, not the opinions of my network or my company. Okay, all of that said, though, the landscape right now in the antitrust arena in our industry covers no less than 20 cases and growing. And the way that I divvy these cases up is really across three categories. The first are the original baddies, the seller plaintiff cases. These are now up to 17 and counting, including the legacy cases, Burnett, Merle, Noslek, et cetera, et cetera. The second category are buyer plaintiff cases. We have two big ones here. That's Batten 1 and Batten 2 in the Northern District of Illinois. And then third, we have our government plaintiff case, NAR v. DOJ, which is ongoing even following a settlement in 2020. So what I'm going to do is a very quick procedural fire hose update here before we get into our panel discussion to sort of remind all of you of the lay of the land. I'm going to fly through where we are in Burnett, where we are on the copycat landscape, where we are on the buy-side cases on PIN MLS, particularly the Department of Justice's involvement there, which is getting more and more interesting by the day, and also on the DOJ, the NAR appeal. After I do this to you, I am going to release you back into the safe and loving arms of Darryl and John for our full panel discussion. Okay, so let's start with Burnett. Obviously, this is our biggie. Last Halloween, a jury in the Western District of Missouri found NAR and the corporate defendants in this case liable for antitrust activity, essentially for promulgating and enforcing rules that, according to the jury decision, amounted to widespread conspiratorial price fixing in the residential real estate transactions across the country. Now, right or wrong, this has happened. And what we have now in this case is a lot of post-verdict motion work happening, including a motion for a new trial from NAR. And more immediately, just this past Friday, Home Services of America, the remaining corporate defendant in this case, petitioned the Supreme Court of the United States, SCOTUS, to review a Court of Appeals decision from last summer. Some of you may recall that Home Services was found by an appellate court that they couldn't be dismissed from the Burnett case, despite the fact that any of the plaintiffs in Burnett who had actually engaged with a Home Services agent had signed a contract that said very clearly that any disputes around that transaction would be resolved via arbitration, not via court, not via class action, via arbitration. Nonetheless, the appellate court there held that since Home Services, the corporate entity, was not itself a party to those agreements, that it couldn't enforce the arbitration clauses. Now, the question in front of the Supreme Court, or that Home Services wants the Supreme Court to consider, is actually kind of one step removed from that argument. Specifically, Home Services is asking the Supreme Court to determine whether the court itself had jurisdiction at all to decide whether or not those contracts should have been arbitrated. In other words, whether the question of arbitration should have not been decided by the court, but by arbitration. This is actually a huge fight. This is something that has been fought out in courts across the country. It's a big deal procedurally, which means there is actually, out of the thousands of cases that the Supreme Court rejects every year, a real chance that the Supreme Court may actually take this case. For the Supreme Court to hear it, they need to decide that there is national import here. And this is a big enough deal where that could happen. I'm certainly rooting for that. Okay, so setting aside Home Services appeal to the Supreme Court, we are all also in the Burnett case assuming that the plaintiffs will move for some sort of injunctive relief. In other words, they'll file a motion asking for rule changes. What we're all anticipating is going to, really change the way that we practice here. That hasn't happened yet. Now, Ketchmark, the lead plaintiff's attorney in Burnett, has said that he's working closely with the Department of Justice around all of this. So personally, I'm thinking that maybe one of the reasons we haven't seen this yet is because all of this is being worked on in concert behind the scenes with the Department of Justice, which of course has an interest in some alignment across the cases. Okay, so in Burnett, what are the paths forward here? Assuming that the defendants' post-verdict motions and appeals are not fruitful, and again, we are all hoping that they will be, but I think as an industry, we shouldn't be putting all of our hopes in that basket. NAR and Home Services, the remaining corporate defendant, will either appeal or settle or a bifurcation of those things. On the appeal pathway, the judge is going to decide a bond amount. There's a narrative out there that, okay, well, NAR won't be able to afford the bond, a reasonable judge, the standard practice here is that the judge will set a bond amount that NAR would be able to pay and that would allow the defendants to engage in the appeal process. So I think we can kind of let that narrative go. NAR will also likely try to get any injunctive relief that is asked for and granted stayed during the appellate process. I don't know that there is a very good chance of that happening. I'm sure that if that happens, they will do their best efforts to do that. But I think we probably need to prepare for changes being dropped down and implemented before the end of an appeal. To be clear here, guys, this is again my personal opinion. I believe that the defendants do have some really strong arguments for an appeal, including that the trial judge applied the wrong standard here, that the jury had to judge the case through a per se standard rather than a rule of reason. Basically, all this means is that the jury was not able to consider a plethora of pro-consumer impacts from our current system, especially first-time home buyers, et cetera, that all of us on the panel will be talking about. On the settlement pathway, if a settlement were to occur, the settling parties would presumably negotiate some broad protections for their members, franchisees, et cetera. I do have a couple of notes here. First of all, John said it before, a settlement is not an admission of guilt. All right, it's not throwing up our hands and saying, fine, they're right, at all. A settlement is a path forward. That's it. Okay, so I'm seeing a lot of sort of comment sections chatter about, well, they're giving up or they're admitting guilt. No, there's no admission of guilt here. First of all. Second of all, I do want to point out that we are not going to see an end to the litigation only on the seller side plaintiffs here, right? We have these other cases. I'm gonna do a quick overview of them in a minute, out of the Northern District of Illinois on the buyer side plaintiffs as well. So these settlements are a panacea on the sell side plaintiffs, but we still do have to kind of work through the buy side plaintiffs as well. The third point here is that any settlement is being scrutinized and will continue to be scrutinized by the Department of Justice. They have purview not over the cases themselves. There's the division of power there that doesn't allow them to stick their fingers into the judgments themselves or the cases themselves. But there is something called the Class Action Fairness Act, which allows Department of Justice to scrutinize for fairness any class action settlement. So we are going to see government activity there on any settlements. Okay, so we've got this huge slew of copycats across the board in addition to Burnett. What's next there? Well, unfortunately, until we get some closure via settlements or some other procedural resolution, but probably settlements, we are going to see more lawsuits. So what's next there is more lawsuits. Also hot on the table right now in the copycat arena is consolidation, right? We've got a big fight brewing right now. Plaintiffs' attorneys are pushing to consolidate all of these cases in the Western District of Missouri, in the same Kate that they just had their big win, so of course they are. And then the defendants are really pushing for consolidation in either the Northern District of Illinois, where 5 of the current 20-ish cases are housed, or in Texas, which has the greatest number of defendants. Right now, we have well over 200 defendants across all of these cases, and at least 40 of them are in Texas. So in my opinion, either of those venues would make a lot more sense than Western District of Missouri. Okay, so real quick, buy-side cases, what's next there? We have 2 cases, Batten 1 and 2 out of the Northern District of Illinois. Same premise, same set of facts, same idea from the plaintiffs on both of these cases. But the only real difference here is the plaintiffs are buyers rather than sellers. Judge Wood, which is the same judge who is overseeing Merle, the first of these cases that proliferated in 2019, had the case Batten 1 in front of her. She dismissed it, a previous manifestation of Batten 1 for lack of standing. She said, no, buyers are indirectly harmed. There's no federal standing for indirectly harmed plaintiffs. Go away, case dismissed. The plaintiffs, being clever, popped back up and said, yes, Judge Wood, you are correct. There is no standing under federal law, fine. we're going to refile with state law. 2/3 of states have indirect standing in their antitrust laws. So these are back alive and well. They will survive. They have survived. Judge Wood is allowing them to survive the motion to dismiss and will consolidate these two cases. So this is real. This is the next on fire car on the track. And this is something we need to pay attention to and make sure that we are, really in any resolution here, paying attention to both sides of the table. PIN MLS, if you will recall, this is one of the early copycats. NAR is not a plaintiff, has never been a plaintiff in this case. The primary defendants are the same corporate set of corporate defendants of the original cases, and PIN MLS, one of our big East Coast MLSs. The reason that this case is so crucial to watch right now is it's really kind of serving as a little bit of a petri dish right now for us regarding what the Department of Justice wants in terms of rule changes. As a reminder, PIN had originally tried to settle out of the case last year. There was a preliminary settlement. The judge granted the preliminary settlement. Department of Justice popped up and said, you know what, this is not enough. You can't just make offers of compensation optional, which is was the central premise of the settlement. We need more. This is not enough for our consumers. The big news here is the Department of Justice needs to file additional support for this by next week. The date is February 15th, I believe. Anthony, correct me if I'm wrong, it might be the 16th. But middle of next week, the curtain will be pulled back on what the Department of Justice is looking for in terms of some rule changes. So that is a big, crucial thing for us to be watching right now. Finally, NAR v. DOJ. So this is once again the Department of Justice keeping their eyes and ears on this, and I think it's really where a lot of these rule changes are going to be determined. So NAR v. DOJ, if you all recall, the 3-judge appellate panel heard the Department of Justice's appeal last December 1st. The lower court decision last January had held that the Department of Justice did not have the right to go backseas on the settlement with NAR back in 2020. The judges on the appellate court appeared, I was not in the courtroom, but according to everyone who was there, very skeptical of NAR's argument that the Department of Justice could not go backseas, could not renege on this settlement. And while I don't like it, I personally believe that we should prepare ourselves for this case to be reopened, which will, I think, conflated with the Department of Justice involvement in the various class action lawsuits, mean that any rule changes and other changes to the way that we practice business will be dictated in great part by the federal government. Okay, so all of that being said, change is coming, so let's prepare for it. And that really is the crux of what all of us are doing here. So with that fire hose download, folks, Darryl and John, I relinquish my mic.
Jessica, wow, what a tremendous job in summarizing really approximately 20 lawsuits right now that are facing our industry. Now, Darryl, my good friend, so there's nothing really happening, Darryl, right?
Yeah, it's business as usual. Nothing's really going on. I will say this, John, by the way, thanks for putting this together, and a big shout out to behind the scenes, your team. You have an incredible team, which says a lot about your leadership. Now, so here's why I'm excited that the folks that are here, because the reason why we put this together was because for me, what I've noticed for the past few months is the training that we do is specifically for agents, and the agents kept coming to us saying, what do we do about the lawsuits and da-da-da. Now, I'm not an attorney, I'm a sales trainer guy, like Anthony is, how to list and sell. But we saw a need, and so we started to train more on that. As a matter of fact, if you all want to write down a website, narlawsuit.com, narlawsuit.com, and you'll see just the plethora of stuff we've been putting up there. In any event, what I keep hearing from agents, and I'm assuming who we're talking to right now are brokers, managers, leaders of their companies. What we've been hearing from agents in the field is, I'm not getting leadership, I'm not getting direction, my association isn't sharing with us as much as you're telling us. So the point being, if there's one thing that I hope that everybody gets out of attending this, is it's not business as usual, that you should start planning. Now, granted, there's no clear definitive decisions made and but as business owners, you need to lead your people. And when we tell them business as usual, that they don't react well to that. That doesn't help them. So, so that's what I'll say on that. Now, let's go to our real panelists, who are the smart ones here. You all got a taste of Jessica, and I realize now I don't need coffee. I can just listen to Jessica for 10 minutes, and I'm ready to go. James is one of the go-to people, so I've been really in on this lawsuit, and I follow James and all of the podcasts and the videos that he has on YouTube. You've got to look at. He's just a brilliant man. And then, of course, Anthony, an active broker, listening, selling, and all in on this as well. So let's start with our questions really quick. And I'm actually going to go to Anthony first. Anthony, could you share what you're doing in your brokerage in anticipation of changes that you've been making?
So luckily, and thank you for having me here, John and Darryl, appreciate you guys inviting me. Luckily, we have been training on utilizing buyer agency agreements and buyer contracts on a pretty much weekly basis since 2012. And this is how our training business, Crush It in Real Estate, kind of spun off of what we do at Lamacchia Realty here with our agents. I've always been a big believer that if you are an agent working with sellers, you would never list a home without a listing agreement. Why are you working with a buyer without a buyer contract of some sort? And we started training on that mostly weekly since 2012. So the notion or the need for a buyer contract, buyer agency agreement, depending upon what state we're talking about, is pretty much old news here at our company. However, I find it very interesting that now the good that's come out of this wrongful verdict that I wholeheartedly disagree with and I am totally against, and I've not been shy about it, is it certainly has woken up a lot of agents and owners across the country. Suddenly, our training rooms are full. People are tuned in. Wait, I have to get that buyer agency agreement. I should get that buyer contract. Will I still be able to get paid? And people are concerned about those kinds of things. So we've been just doubling down on our efforts on those kinds of things, many of which we were already doing, but we've certainly turned up the volume. We've also turned up the volume on having open discussions with the agents in our own company. I want to clarify that. We're not talking about commissions or getting paid with folks who are training customers of Crush It in Real Estate, but in my own brokerage, Lamacchia Realty, we're having conversations with the agents about how are you going about getting paid if there is a listing or a seller who decides they're not offering cooperating brokerage compensation. What do you do then? We've seen this much more of that, a tiny bit more of that since the verdict in October. And we've also seen and heard more talk of it. So we're preparing the agents for the day that may come. I keep hearing it may come. Hopefully we'll have a better idea next week after the DOJ files their statement of interest in the MLS PIN case, as Jessica explained. But if the day comes that the DOJ gets what I hear is their wish, which is to eliminate any talk of commissions in the MLS, I want to make sure our agents are prepared for it. And we're already preparing for that with training, with forums, etc.
Awesome. And by the way, I just want to highlight that too. You see, I hope some of the brokers watching this and leaders that wrote that down, buyer agency training. In other words, you need to have a plan because that's what the agents are hungry for. James, what have you been noticing or would suggest that brokers can start to do to anticipate the changes coming down the pike?
Yeah, so I mean, the first thing is, like, as we're all going to talk about, we don't have a crystal ball. I think for those of us that have been following this, my bet is that contractual offers of compensation in the MLS will be banned. I also going to make a wild statement here. That rule has to actually happen in order for future class action lawsuits not to exist, because
Yes.
The rule is what's actually causing the problem. And if you don't get rid of the rule, 4 years from now, we're going to deal with an entirely new class of people that are going to sue for the same things that we've already had in place. So I want everybody to chew on that when I make these comments. In September, like Anthony, we brought our offices out, 430 of them at the time, it's 600, but the point was we brought them out and started to retrain them. You know, Anthony made a great comment, and I just get stuck on this. When I'm in a room asking people questions or I'm doing a keynote, I ask them, how many of you think working with a buyer is more complicated than working with a seller? I don't know how to turn that off, by the way. Is working with a seller, and they'll all raise their hand and say, yes. I'd be like, great. How many of you would sit down with a seller and do a listing without an agreement? Nobody obviously raises their hand. I'm like, well, why the hell are you working with buyers without a contract if it actually takes more work? So
Right.
What I'm trying to teach everyone, regardless of any of these outcomes that we're going to see what this is going to be, I think you need to plan for a future where contractual offers of compensation do not exist in the MLS. Plan for it. It doesn't happen, great, but plan for it today, because you're going to get better at your job, because you need to sit down and start treating your buyers like a seller. You should be meeting with a buyer and doing a consult. If you've never done it because you haven't had to, start now. Don't take a buyer appointment without saying, I want to sit down and talk about what you're looking for. Second piece, get a buyer presentation in place, just like a listing presentation. Sit down and articulate your value in very clear, finite detail. NAR did a fantastic piece called 105 Ways That Agents Work with Buyers. You can look it up online if you want. Take that document, pull the 105 things and put it into a buyer presentation. Do it today. Start training and treating them like a seller, planning now. To Anthony's comment, talk about a buyer rep agreement. Say it's something that we do, because in order for me to do all this work for you, like you, I have to be compensated. We're in a world still where compensation is going to come from the sell side, at least for some portion of time. It's easier to learn to do those buyer rep agreements right now where that still exists versus a future where this is potentially going to change. But I say this all the time, and John's made this comment as well. The sky is not falling. I've looked at this from more than I even want to explain every angle. I actually think long term, this future is going to look different, but actually better. My comment is this: I'm no longer having the seller's agent dictate my compensation. I can sit down with a buyer and articulate my value and talk to them about what I'm worth with confidence. Number two, everyone knows I've been, vocal about the changes that the National Association of Realtors needs to do, mixed into the fact that they're an incredibly important part of our industry. They are the only ones, make this really controversial statement, not the American Real Estate Association. The National Association of Realtors is the only organization that can lobby Fannie, Freddie, Ginnie, and others to get compensation financed in a loan. Period, end of story. There's no other debate into it. So as an industry, while we're talking about all these issues, we also have to understand that advocacy and the advocacy that NAR does is what's going to actually help us move into this new future. Why I share that is, that future is going to look a lot like commercial real estate. And that's the thing I want everyone to understand. You're going to sit down with a buyer and articulate your value. You're going to talk to them about what you're worth. You're going to ask them to compensate you. It might be that the future is they pay for part of that through the loan. You might have the seller provide a credit back to the buyer to help pay for part of it. It becomes a negotiation, and candidly, we got to get better at that anyway. So everyone should be teaching negotiation tactics within your brokerage. Learn to be a better negotiator. Learn to do a buyer presentation. Learn to talk about that buyer rep agreement. Get confident, get really, really articulate about what you do, get passionate about what you do, what both of you guys do and what Jessica does. We all talk about it all the time. This isn't not a skies falling thing. I absolutely think for a percentage of the industry that's not good at their job, it will be for you, unfortunately. But I think for the industry that's professional, that's going to rise to the occasion, I think this is going to be a different outlook, and we will thrive in that market. So,
James, I think everyone on this panel agrees with you, and you're spot on, okay? As everyone that's spoken thus far is. Both of you on the brokerage side, Anthony and James, you espouse transparency and clarity. That's what it is. It's transparency and clarity. And we have to be, correct me if I'm wrong, or you think I'm wrong, especially on the buyer side. We need to be able to articulate what it is we're doing.
Yes.
And that includes, and you mentioned, James, and I know I've heard Anthony say this infinitum, and I've heard Darryl talk about negotiating. My gosh, our negotiating skills on behalf of our clients on the buy side, okay? Literally, we have to articulate to our clients, prospects, what we are going to do for them on the buy side and how we're going to be compensated, because we haven't had to define that the way we have to going forward.
Correct. And John, I want to add something that I think is super important. So I've done some studies with the Wave Group on a project I've been working on. I'm going to give you two stats that the industry does not know that you're going to hear today. Number one is buyers typically think a buyer's agent spends 15 to 20 hours working on a transaction. Let that sink in for a sec, because we all know that's utter nonsense. On the other side of that coin, because I have access to data that no one's seen yet, the average agent will spend between 80 to 100 hours working with a buyer to get them into a property. That's the problem. Perception is 15 to 20, reality is 80 to 100. We suck at articulating our value. We got to close that gap. And by the way, everybody else has seen these studies from all different consulting firms that have shown this stuff. Buyers are willing to pay. They find value in representation. They don't want to go to a model like Australia and others where there isn't buyer representation. They just need to clearly understand what we do. And I think that gap will close, and I think that people will have that opportunity, and I think representation will exist. It's just going to look a little bit different on how all that's done from a compensation perspective.
Let me ask Darryl and Anthony. And Anthony, I, having just come back from your incredible convention up in Boston, you mentioned that you've created various scripts and dialogues on this crisis for your agents. And then Darryl, I'd like you to step in also and tell us how you're helping and advising your thousands of agents so they can be better prepared. So start with Anthony. Tell us a little bit about the scripts and the dialogues you've created.
Well, as I said, these are things we started creating 11 years ago. And some of them came from scripts even years before that, but teaching newer agents what to say, when to say it, how to answer questions from buyers, a lot of that is necessary to make them comfortable and make them better at their job, just like other professions. I recently debated Mr. Ketchmark somewhere else, and one of the things I pointed out to him is I said, hey, you keep criticizing trainers in our industry. Every industry has trainers on value and things like that. And if we didn't have trainers, that would mean that the commission prices are fixed. So the fact that we have trainers shows that they're not, right? Because trainers wouldn't exist. So, talking about how to articulate your value, get buyers to see the difference, get buyers so that they don't look at realtors like they're a dime a dozen and, oh, let me click contact agent on my phone and 4 realtors call me, and who gives a damn if I blow off 1 or 2, because there'll be more coming down the line. The realtors who are best at articulating their value, helping buyers find properties, find a selection of properties, which right now is a frustration point for buyers. They feel like they can't find enough homes because inventory is low in most of the country. Helping them find good deals on properties, finding places that they can get a good value, making it easy for them to buy, articulating that to them, explaining that to them, inviting them in for a consultation, as James mentioned, sitting in the consultation, walking them through the home buying process. Those types of things should be standard procedure. And I'll tell you part of what screwed it up a little bit. We had a pandemic, as everyone knows, coming up on 4 years ago. The market started moving so fast, it just became a race of who could run the fastest, who could run out the door, show the home the fastest. And some agents, frankly, got rusty on articulating value. The scare of the commission not being offered in MLS, the scare of, wait, how am I going to make sure I get paid, is making a lot of agents refocus their energy on articulating their value, having conversations with buyers, sellers, etc., because many sellers are also buyers. So, without taking up all the time, because I recognize there's others here and Darryl's going to speak, but these types of things are critically important. And I want to go back to one thing you said before, John, about the sky's not falling. No matter what the hell happens here, case is, no matter what any of us say in the screen, there will always be a need for realtors. Think about since October. You got Michael Ketchmark on every damn news station he can go on, trashing realtors, trashing the National Association, trashing everybody in the business. It's a rigged system. They're picking pockets, taking money that doesn't belong to them, et cetera, et cetera. What are buyers still doing every day of every week? Contact agent. Buyers are still hiring realtors. Sellers are still hiring realtors, despite the news being mostly negative about our industry for the past 4 months. So I just want to point that out to everybody. Realtors aren't going anywhere.
I want to get to Darryl for a second. Darryl, just bridging what Anthony just said, and then after Darryl, we're going to grab Jessica back into this conversation as well. You know, you're right, Anthony. I believe our industry, but our services, we're not Blockbuster, we're not Kodak, we're not BlackBerry, okay? We're not models that are antiquated and gone by the wayside. 90% plus or minus of the consumers out there actively want to deal, home buyers and sellers want to deal with us. Darryl, take it away. Tell me your thoughts about what we should be doing.
So there's a couple of things. Thanks, John. Is you had asked the question about what specifically am I telling my agents how to handle like dialogue? And one of the things, because everybody's hit on it, and I hope everybody's taking notes. And one of the notes you wrote down is get my agents better at communicating value to buyers, because like James said, regardless of what the results are, that's just something we should be doing anyway. And one of the things that we're teaching our agents, John, is when you sit down with the buyer to distinguish the value of them hiring you as the buyer's agent, is there's a distinction in all business between a customer and a client. See, when you go buy food at the grocery store, you're a customer. When you go to buy a car, you're a customer. But when you go hire an attorney to represent you, you're now a client. When you hire an accountant to do your taxes, you're a client. With a client, there is a fiduciary obligation to put the client ahead of everything else, as long as you're not breaking the law. So when a buyer comes to an agent, they have the same choice. They have to decide, do you want to be treated as a customer, or do you want me to treat you as a client? As a customer, my commitment is to the transaction. As a customer, I might have depending on what state I'm in, I may be obligated to the seller as opposed to the buyer, meaning to get the seller the highest price and get you to pay more. So that's when you're a customer. I want you to be my client. I want to represent you, and this is what I'll do for you. So anyway, that conversation is powerful for people to get that I need to hire an agent and represent me. The other thing, and then we're going to go to Jessica, as you said, because in case people don't know, Jessica's also in charge of oversees the training, all leading RE, so brilliant person she is. She's always got something going on.
Darryl, we're going to ask if Jessica could be cloned. We're going to get that at the end of the.
Listen, with AI technology, that's very possible. Yeah. But here's what I do want to say, like James touched upon it, Anthony and John, you too, about the sky is not falling. So here's what I want to say to that. And I totally agree with James about we're going to become stronger because of this. And what we've also been telling our agents is the concept of test pilots in the armed services. The whole job of a test pilot is to take a new piece of equipment, get it up in the air, and push it beyond its limitations. The commitment of a test pilot is to find a breakdown in the equipment. That's the commitment that they have, because they know from the breakdown, they can improve the machinery, the scientists, the engineers, and they improve it, make it better. That's the breakthrough. As a matter of fact, you cannot have a breakthrough without a breakdown. So anytime that our industry has been faced with breakdowns, whether it was when we went from MLS books to going online, and then when we had to share data, all of this stuff, when we had the sky falling in our industry, COVID, how the hell are you going to sell a house that you can't show because you're stuck in a home? Every time that we thought the sky was falling. We came out of it stronger because we turned the breakdown into a breakthrough, and that's what's happening here. So Jessica, what do you, I'm sorry, John, you want to take it?
No,
Okay.
I want to, very well said, Darryl, but I'd like to, specifically for Jessica, in less than 2 weeks, Jessica and James are going to be hosting your respective conventions out in Las Vegas, okay?
Yeah.
And in Jessica's case, there's going to be 575 brokerage owners from all over the world. When you think of all the things we're talking about now, there's a couple of things we haven't really touched on, but I believe are very important. I'd like your opinion on this. Fair housing and dual agency, okay? And then James, when we come to you right after Jessica, let's talk a little bit about what you're going to be espousing at your show and for your agents. We'll start with Jessica.
Yeah, thank you, John. Great point. So sort of where the intersection of my training hat and my legal hat intersect, there are a few really important points here. One is on fair housing. So as you're looking to increase training across the board, I think especially on the buyer side of things, make sure buyers agents and those who train buyers agents that you're really training, doubling down on unconscious bias and fair housing training. NAR has Fair Haven, whatever resources are at your disposal. And the reason is, as we see an increase in the possibility of buyers having to reach into their pockets in order to pull out sort of direct compensation under these buyer agency agreements, which buyer representation agreements that everybody should be signing, I want to make sure that unconscious bias is not getting in the way as you vet buyer clients especially with an eye to protected classes as folks walk into your office. So train on unconscious bias and ensure that you are working your list of prospective buyer clients on an objective set of criteria. So that's first. Fair housing is more important now more than ever, especially as we're looking for some real vulnerability among first-time home buyers, among underrepresented communities. Veterans are facing additional hurdles now with the threats that are presented by these cases. So that's fair housing. And then on the seller side, I want to make sure that everybody really is focused on doubling down on dual agency training. And that's because if all of a sudden there are unrepresented buyers going it alone or quasi going it alone out there in the ecosystem, that as you work to push through a transaction, that you really are clear on what you can and cannot do when it comes to communication and helping that buyer navigate that transaction. So those are two risk management points. One other, just sort of while I got the floor, is I want everybody also to really sort of think through as you're talking to your listing clients, so listing agents talking to your sellers regarding their choices here. Make sure that everybody is really thinking through the fact that unrepresented buyers are not necessarily good for anybody. I am hoping that we don't see this, but anticipating that we may see an increase in frivolous lawsuits coming from unrepresented buyers who don't know how to navigate a appraisal report, who don't know what an inspection report means, who don't understand any of these disclosures that are usually helped through and translated by our buyer's agent. They're going to get mad, they're going to have buyer's remorse, and they're going to sue. So once again, there is so much security and safety from the sell side to have a buyer who's represented on the other side of the table.
Yeah,
Anthony, you raised your hand there.
Yeah, I agree with what Jessica just said. She's completely right about that. And I want to take it even further. And by my doing this, I'm actually going back to John's request of talking scripts. One of the things we've taught agents or helped them clarify and find their words on is telling sellers the truth. You know, some of these sellers are seeing these news articles that are twisted in all different ways and saying, well, should I be paying the buyer's agent? I read this article that says blah, blah, blah. And one of the things that we've pointed out is, hey, look, you don't have to pay the buyer's agent. Okay, I know that some of the MLSs like MLS PIN, which full disclosure, I'm a member, I'm a shareholder, but some of the MLSs have said a minimum of $1. I heard Miami used to say a penny. Now they say nothing. But sellers are not forced into paying any specific percentage or any large amount. However, if a seller brings that up, an agent should explain the truth to the seller, which is, hey, Mr. Seller, Mrs. Seller, if you don't want to offer cooperating brokerage compensation, you don't have to. However, if an agent takes out a buyer to see homes A, B, C, and D on a given Saturday, and A, B, and D are offering cooperating brokerage compensation, but C isn't, and C is your home, that buyer agent becomes obligated to say to the buyer, hey, listen, happy to show you A, B, C, and D, but home C is not offering any compensation for me to bring you there to see the home. And if you want to buy that home, that's okay. I'll write the offer, but I'm going to need to work with you on getting paid, just like our buyer agency contract representation, whatever you want to call it, just like our buyer contract states. When most buyers hear that, okay, you take a first-time buyer, you take a buyer that's even a move-up buyer. Wait. Home A, B, and D, you're getting offered compensation from them, but home C, you're not. I don't want to see home C, because buyers are the ones driving the process. They're the ones making those decisions, and they're going to be likely, not every one of them, but most of them, to say, I don't want to see that house. I already have to come out of pocket with closing costs, my down payment. I have to buy homeowners insurance. I don't want to have to pay you as well. And if you can get paid from what the seller is offering on homes A, B, and D, those are the homes I want to see. And that is necessary to explain to a buyer so they're fully in the know.
Very good. James, some comments?
Yeah, I mean, I have a maybe slightly different approach to that. I mean, I agree to some aspect of that. You wanted us to give tangible things, John, in this webinar, so I wanted to throw just some key things. I'll seal up the buy side first to make sure we get them. I think there's two designations you all should look at. Again, if you're going to differentiate yourself in the market and why somebody should work with you as a buyer's agent versus somebody else. So there's two of them through NAR. There's the REAN designation called the Real Estate Negotiation Expert. You should look at that. And of course, ABR, accredited buyer representation representative. I think those are two to glance at. Again, debating designations, whether they work or not, it's a differentiator, which is the point that I'm getting at. Being creative about stuff. Here's another one, an idea that I think you could look at. When you're talking about what differentiates you as a buyer, for example, if a house isn't staged, why don't you offer a service through some of these new AI image technology where you'll pay to actually show them what a staged house would look like virtually, an extra service that you're doing that maybe another agent doesn't do. Get creative. Start to think about what is going to separate you from other agents in the market. 3 books that I'm recommending that you write down and do. Getting to Yes is a negotiation book. The Art of Negotiation is the second, and Never Split the Difference, which is everybody's favorite, is the third. Those 3 books you should start learning. Now I'll come to the sell side, because I think this is, Anthony and I are in similar opinions on this, maybe slightly different approach, but I do think you have to talk to the seller about understanding how our industry operates today, why we offer compensation to the buyer's agent, which in my opinion is more along the lines of the fact buyers are strapped for cash. And to Jessica's comment, she said earlier, unrepresented buyers are a massive legal risk. They are. You could also tie that into dual agency, by the way. If you go back in time, the fastest way to get sued was to do dual agency on a transaction. So to me, it's a conversation of this buyer that's likely to buy your home is going to be a first-time home buyer. They don't have any money. They've been saving for 10 years trying to be able to do it. In order for a deal to come together, you're likely going to have to offer some level of compensation. Mr. and Mrs. Seller, it could be that you offer it through the MLS, could be a credit back to the buyer, could be that you pay the buyer's agent's compensation directly. These are conversations that we need to be having with the seller now, while the model is still what it is, but preparing for the future. I'd be really careful about why and how you're explaining this, in the sense that it's designed to help the buyer have representation to limit legal liability, because an unrepresented buyer, to Jessica's point, is a massive risk in the transaction. But I absolutely think we need to be having those discussions now and talking about that strategy And it may be that the seller doesn't want to, which they've always had a right not to do. It's been that way since I've been alive on this planet. But explaining to them exactly what that means, what potential negotiation issue that might be, and if a buyer can't afford to pay their agent, then it becomes an issue that we're gonna have to negotiate through it. Again, you're hearing me come back to negotiation. Sellers agents have to learn to start talking about this stuff now. Buyers agents need to learn to start talking about this stuff now. If I'm wrong and all of us are wrong, then it's status quo. You'll be better agents anyway. You just learned how to be better at your job. Congratulations. If we're right, you're prepared for this new future. So some tactical things there is start those discussions when they're easy, like right now. And then when they become harder, it's not really hard because you've been doing it for 6 months or however long it might be before some of these changes come down the pipeline. So,
And John, if I could just, John, I just want to add to what James said, that because I love the specific strategies and tactics that we're giving the people watching, is that back in my day, eons ago, we used to have commission agreements that were signed outside of or in addition to whatever was signed on an MLS form or something. So and we talk about transparency as well, that I think it would be a good idea for a broker to have their own set of forms, separate from the association, separate from MLS, that says it plainly that the homeowner has chosen on their choice, to pay or not to pay, whatever. And then even when you negotiate an offer and it gets accepted, there probably should be a commission agreement with the offer that everybody signs. The buyer signs, the seller signs, the two brokerages, so everybody's clear. It's totally transparent. I think as leaders, if we start thinking, what's the best way to protect myself from a lawsuit if someone's going to bring me in for something? So paperwork, transparency. But anyway, that's it.
That's exactly the kind of thing we created years ago, and then really honed in on the fall and started training our agents on. And you know, the notion that buyer agents need to accept whatever the seller agent or seller is offering, if they're offering something, is wrong. I mean, agents, the buyer agent representing the buyer, that's a discussion between them and their buyer, how much they're getting paid. Now, there are limits to how much closing cost credits with different mortgage products will allow. You can't get, FHA allows a 6% closing cost credit. Fannie Freddie generally 3%. So there are limits, but there are ways around it, and that these types of things can be negotiated. But I stand behind what I said before. If a home is not offering compensation, that puts the buyer agent in a situation where they have to have that conversation with the buyer, and the buyer may well choose not to see that home. And that's something that agents should be aware of and should be ready to explain to sellers and buyers if they're representing a buyer.
Well, team, I think we've done our best to try to spend about an hour with all of our guests to try to help them understand what they could be doing, should be doing in the next few weeks, starting now, to help change their business for the better, number one, and have an understanding, a clear understanding that what's in front of them, what's in front of our industry is, a big dark cloud. However, as Jessica pointed out, we need to watch these, be part of these suits, and make sure we're educated as to what the real impact is of what's coming down the pike. We started talking about, one of the things was all of us articulated the need for strong negotiation skills, stronger than we are right now. And I think everyone on this call right now is a strong negotiator. All 3,600 of you that signed up to be part of this today, I'll bet you're all great negotiators. Well, guess what? We can all get better, and we can also understand how important it is to articulate that with transparency and clarity, what we're going to do for buyers and what they're going to pay for how they're going to pay for our services. Because clarity, transparency can, as Darryl so well said just a moment ago, okay, review it with everyone. the buyer, the seller, yourself, so that everyone signs off and understands what is your role and what you're being paid for in the process. I think I'd like to have a very quick around the world here, and have each one of you say your 30 seconds on what you would advise someone on this call to do tomorrow to be a better agent in lieu of what they're facing. Let's start with James.
Buyer presentation, buyer rep agreement. Go learn them, get comfortable with them, sit down with them, get used to doing them right now where you don't have to potentially have the buyer pay anything. Make that part of your routine. Fall in love with those documents. Use them as a pillow. I don't care what it is. Get used to those 2 documents and those presentations, and you'll be fine.
Use
The
them
rest
as a
of it
pillow.
we'll take
That's
out.
great.
Just
Anthony.
sleep with them. Get super comfortable with them. I don't care what it is. Just get really comfortable with those presentation and documents. So.
Anthony.
I agree with every word James just said. I echo it. I don't need to say it again, but it's time agents start taking training real serious and taking the need for training at whatever company they are at serious. And if their company and their broker is not talking about these kinds of things and preparing them, they had better think about making a change, because the time to get serious on this is not 3 weeks or 3 months or whenever from now that something comes out and says by X date, this changes. That's not the time to get serious. The time to get serious about this was 3 months ago. So if an agent is serious about their business and serious about living through this change that is upon us, they better make some actionable moves here.
Great. Jessica.
Ultimately, everything we do is for our consumer, both the buyers and the sellers. And I think keeping a couple things top of mind in that vein. First of all, make sure that transparency and clarity is key. They do not sign anything. They do not leave a conversation without you double checking that they understand how things work and what your role is. On the value prop, we're talking value prop as an industry incessantly. I wholeheartedly agree with what my panelists said today. I want to add one additional layer there, though, which is as you are honing all of these amazing things that you do for your clients, ensure that you filter all of that through a vein of listening, right? You cannot provide value, no matter if it's 110 things that NAR has on that list, or how many hours you're doing, unless you know what your client values. So as you talk to those buyers, make sure you are creating huge swaths of space for you to absorb what they value before laying your value on top of something that may not be at the top of their list.
Great. Darryl, you are going to be, you're an evangelist, okay? And you're going to be talking to thousands and thousands of agents over the next month, 2, 3, 4, 5. What are your 30 seconds of thought there?
Well, my 30 seconds is this. Number one is, got it down, narlawsuit.com. It's a great resource. That's number one. Number two, I got 3. Number 2 is you must subscribe to John's RISMedia's Premiere. I'm not saying that for any other reason, that's one of my go-to places. Oh, good, you popped it up. That's one of my go-to places that I go to get educated and stay ahead. By the way, just be clear, every morning you should check your email. They send you an email. Here's a summary of the hot news. Click on it, read it. That's part of my ritual every morning. The third thing I say, John, then I'll kick it back to you, is this. We as an industry have been around for over 100 years as an association, but as an industry over 150 years. The majority of homeowners of all that time, over 85%, hire real estate agents to sell their house. If we didn't provide value, we would not be around for over 150 years. And instead of 85+% people listing as agents, they would be FISBOs. So obviously, we've been doing something right. Don't forget that. Don't let 8 people in a box dictate how you feel about you. That's it.
Darryl, well said. I am very proud of what we do, but I'm proud of what all of you do to help our industry be better. Real estate professionals help our neighbors, our friends, our colleagues become homeowners, and to achieve their goals and objectives. Now, replays of this session will be available later on today to all attendees who received an email with instructions on how to watch this webinar. On behalf of RIS Media and my team that does an absolute tremendous job, I'd like to thank everyone involved for making this happen. I'd like to thank all of you that are watching and being part of this. You saw how you can become, if you're not already, an RIS Media Premier person and subscriber, and get our information every single day and all of our reports, etc. I wish everyone great success. I thank all of you, Jessica, Darryl, Anthony, James. You're all absolutely incredible real estate professionals. I look forward to seeing all of you in person soon. Thank you very much for being part of this.
Thanks, John. Thanks, everybody.
Thanks, John.